interesting activities in this regard lately, especially with the latest dust-up at CBS. So this should be very interesting. We have Joanne Bird, Tim Gleason, and Sandy Rowe with Bob Applegate as moderator for this program. Now, it will be held on the 4th floor upstairs, and the program, as usual, will begin at 12:15, but we are going to be assembling at 11:45 for any of you who want to debate on the PDC report, the recent PDC report, because we're going to give 15 to 30 minutes for that debate, and then we do have to vote on it. Now, the PDC report that just came out in your bulletin last week is one of our typical research reports, which are in-depth and impartial, and they usually take a year or more to produce. So prior to voting on it on this Friday the 28th, we're having a program on Wednesday the 26th over here at our City Club Commons office. It's on 9th and Washington, to begin at 5 o'clock, to begin at 5:15, sorry. And people will have an ample opportunity to discuss it and debate it and give it its full due before we come to the program on Friday to vote on it. So again, it's be on the 4th floor. If you're interested in debating the PDC measure or the report, please get here by 11:45. Incidentally, seating for this pre-event, the Wednesday evening program will be limited, so if you'll call the City Club or email them to let them know you'd like to attend, just RSVP to be sure we can get you in. We're also involved right now with the Community Strategy Forums, which are 6 forums throughout February addressing the 6 priority goals set by county budgeting process. City Club is co-sponsoring this with the Multnomah County Citizen Involvement Committee. And also we are hosting post-lecture discussions after the Illahee Lecture Series. They begin, it already began on January 18th. And this whole thing we must have already done, because I'm certain that you had a great time when you came to enjoy these, but we will be continuing these post-discussion lectures. Now, we're also looking for nominations for the Board of Governors. We want to have all of the members have an opportunity to nominate someone that they think has been of great service to the club and would serve the club well on the Board of Governors. If you can get that information into Wendy Willis before February 18th with your recommendation and why you're making that recommendation, it will be put in for the nominating committee to discuss along with the other nominations. We'll be beginning our after-hours series called Final Fridays at the City Club Commons next week, January 28th. And it's just going to be a little informal event. Voila, our catering and restaurant host will have wine and beer and food and soft drinks. And it's over here. Just mark your calendars. We're starting it at 4:30. We'll go from 4:30 to 6. Just an opportunity to mingle with your interesting City Club members and guests. Our Citizens Read will be this 2 weeks from Monday, January 31st at the City Club Commons, and it's Bobo's in Paradise, finally. I think I've been announcing that for 4 months. Next month's book will be February's selection, is Jane Jacobs' classic, The Death and Life of Great American Cities. And that's co-sponsored by Portland Streetcar. So again, all of these events are outlined with on the website along with the City Club's blog at www.pdxcityclub.org. And you can also find it in the bulletin. Now, I'd like to recognize our sponsors this quarter, for whom we're very grateful, and they are Nike Incorporated, Portland General Electric, and Preston Gates and Ellis, LLP. So now on to our program. I'll first introduce Ross Day. He joined Oregonians in Action in January of 2003 as the Director of Legal Affairs. He previously practiced law with O'Donnell and Clark in Portland, where his practice emphasized land use law, takings litigation, and civil rights. He's currently an adjunct professor of political science at Chemeketa Community College in Salem. Lane Shetterly has been the director of the Oregon Department of the Land Conservation and Development since February of '04. And prior to his current appointment, he served 7 years in the Oregon Legislature, where he served as Speaker Pro Tem of the House from 2001 until he resigned to become director. He is still chair of the Oregon Law Commission, a position he's held since 1998. Bob Stacey is the executive director of 1,000 Friends of Oregon, where he was staff attorney from 1975 to 1986. From 95 to 97, he was a partner in the Portland law firm Baljanik, LLP, and from 1997 to 2000, he served as the executive director of policy and planning for TriMet. He was also chief of staff to Oregon Congressman Earl Blumenauer in 2001 and 2002. So welcome to our panel, and Bob Stacey will begin.
Thank you, Corleen. Good afternoon. 1,000 Friends of Oregon attracted a little attention last week by filing litigation challenging the constitutionality and validity of Measure 37. And we firmly do believe that Measure 37 violates the Oregon Constitution on multiple grounds. However, Measure 37 has fundamentally altered the politics of land use in Oregon. So we will be working to obtain replacement legislation in the 2005 session that can pass constitutional muster and be responsive to the message sent by the voters in November. It's important to remember that the election on Measure 37 was not a vote to repeal Senate Bill 100, our statewide land use planning law. The same electorate that voted for the ballot measure title, that voted that government must pay, has repeatedly said, by equally large margins, that it supports Oregon's land use planning. Oregonians hold these two views, which they do not see as contradictory. We Oregonians want government to protect our neighborhoods and our wonderful working landscapes of forests and family farms, and we want government to do that job fairly. But land use under Measure 37 is anything but fair. Measure 37 actually creates inequity and unfairness. The measure says government must pay if regulations reduce the value of property, or else waive the regulations. Because the measure provides no resources for payment, that means state and local governments are forced to waive zoning that was designed to protect neighboring land uses from incompatible development. And Measure 37 puts the livelihoods of Oregon families, particularly farm families, at risk. Since the measure took effect on December 2nd, demands have been made for waivers to allow building major urban scale development on agricultural land. Here are a few examples. 840 houses on 260 acres in the pear orchards of the Hood River Valley. A casino and related commercial and residential development on hundreds of acres of French prairie farmland just west of I-5 near the Marion County farming community of St. Paul, and more than 70 houses on the shore of Wallowa Lake next to Chief Joseph's gravesite. Farmers can't compete with urban development. Residential neighbors drive up operating costs and constrain intensive agriculture. One waiver may force neighboring farmers who are eligible for these claims to seek waivers of their own in a domino effect. And the claims currently filed are just the tip of an iceberg. We're on the brink of marring Oregon's special places and destroying the state's most productive farm economies, located in places like the Hood River Valley, the vineyards of the Red Hills of Yamhill County, the croplands of Sauvie Island, and Washington County's Tualatin Valley. Driving farmers out of business against their will isn't fairness. Giving special rights to a narrow class of property owners isn't fair. Devastating Oregon's landscapes is not what the people of Oregon voted to do on November 2nd. So what can we do about this? We think the legislature has a job. Develop replacement legislation that accomplishes both the things that Oregonians want: fairness to property owners and land use laws that protect our communities and countryside. We believe that those laws that replace Measure 37 should have three parts. First, Measure 37 should be changed to eliminate the process of granting waivers to zoning altogether. None of us, as property owners, should have to fear that one of our neighbors will be able to ignore with impunity the laws that are supposed to both limit and protect all of us. Thank you. Second, the legislature should identify real categories of hardship resulting from the land use laws. I'm not talking about the hardship of not being able to build 860 houses or a casino on prime farmland. But those property owners with a long-standing intention to build a house that was never permitted, fall into a different category. In many cases, though, even that development should not be allowed, where it would adversely impact important agricultural or forest lands and operations. In those cases, we need to find a way to compensate for the refusal to allow development, thereby implementing the intentions of the voters for fairness. One way to do that sounds arcane, but is very simple, is through transferable development rights, where rural property owners are able to sell their unusable development right to a developer of land newly brought into an urban growth boundary. Programs like this have been used in more than 100 communities across America, and they wouldn't cost the state's general fund a penny in compensation. Finally, there's a third way to address the fairness issue in legislation, by identifying land use regulations that unnecessarily limit development and relaxing those laws. But this is not an easy undertaking. For example, some people argue that there is a lot of farmland being protected in Oregon that's not particularly important for farming. But we need to proceed carefully with those arguments. All of us recognize the agricultural value of places like Sauvie Island, the French Prairie, and the Hood River Valley. We've even come to recognize that the Red Hills of Dundee, which were written off 40 years ago by county planners as just too steep for real agriculture, are some of the best Pinot Noir grape growing lands in the world. But what about all that sagebrush east of the mountains? I confess I never thought very much of the land that you see on either side of Highway 20 driving east of Bend toward Burns. But I've learned that that's where Doc and Connie Hatfield and other ranchers raise the naturally fed, hormone-free cattle that come to our tables as Oregon country beef, a real Oregon enterprise, sustainably grown, of high quality, on land that many write off as worthless. Today, more than ever, our decisions about how to mend Oregon's land use laws must be based on solid evidence, not anecdotes. That's why many of the changes in the land use laws that some are promoting today in the name of fairness should be studied more carefully through a process known variously as the 30-year review or the Big Look. Governor Kulongoski has proposed the formation of a new Blue Ribbon Commission to lead a 3-year-long review and analysis of our land use planning system. It would conduct fact-finding and professional research about the accomplishments and shortcomings of our land use laws. The commission would seek out public opinion and involvement using modern technology and techniques rather than relying on canned testimony by the usual suspects. And this new body would recommend changes to the 2009 legislature as necessary to ensure that planning is responsive to Oregon's needs in the next 30 years. Now, of course, this will provide an opportunity to refine and revise Oregon land use laws as needed, but it will also provide an opportunity for a new generation of Oregonians who've never heard the sound of Tom McCall's voice and don't remember various key events of the 1970s to develop their own vision for the future of our state. So does land use planning in Oregon have a future after Measure 37? Ultimately, that depends upon the beliefs of those Oregonians about their communities and this place on earth. How will they decide those questions? I'm indebted to Larry Wallach, the Dean of the PSU School of Urban and Public Affairs, for pointing out a theory advanced by author and journalist David Korten. He argues that political discourse these days focuses on three basic questions. First, how will we prosper? Second, what will make us secure? And finally, how will we find meaning? Oregon's 30-year-old land use planning movement, with its vision of keeping our working landscapes of farms and forests, of towns and neighborhoods with housing and transportation choices for all people, exciting public spaces, immediate connection to nature, and its vision of transmitting the best of Oregon's natural heritage to our grandchildren, has responses to all three of Korten's questions. Measure 37, with its anti-government, beggar thy neighbor impulses, responds to none of them. In the near term, the effort to avert or mend the damage caused by Measure 37 will occupy all of our energies in the land use planning arena. However, in the long run, in the public discourse, I have no doubt which vision will prevail.
Thank you very much to the Portland City Club for inviting me here today. I have to tell you that since the passage of Measure 37 on November 2nd, a lot of groups such as yours who are wrestling with the reality that Measure 37 passed and passed by such a wide margin haven't actually given us a call and said, hey, can you guys come here and maybe explain this thing to us? I am one of the co-authors of the measure. That in some minds makes me the enemy, and some people think that makes me a hero. But what I can tell you is it makes me awfully proud, because contrary to what others have been saying about the measure and about Oregon's land use system, it's not fair. And I'm sure many of you were shell-shocked by the passage of Ballot Measure 37. I can't help but, irony is very ironic, as they say, and I can't help but think that this very discussion today is being sponsored by two corporations that oppose the measure. In fact, they're very shocked as well, not only at the passage, but by the margin which Ballot Measure 37 passed. Some of you are likely asking yourselves why. Some of you are likely asking yourselves, how could this happen? And some of you are likely asking yourselves, okay, now that it passed, what do we do next? So I'm going to take the easy question first. Why did Ballot Measure 37 pass? In December of 2003, Oregonians in Action conducted a poll. I'm not going to bore you with all the results of our poll, but the most significant result, we asked everybody, what is your overall view of Oregon's land use system? 58% of the respondents said it was barely fair to poor. That's nearly the margin by which Ballot Measure 37 passed. The responses we received in our polling demonstrated to us what we already knew. Oregon's land use system, for all the hyperbole you hear in the papers, is not popular with Oregonians. But unpopularity, or the belief that it's not popular or effective, isn't in and of itself enough to explain why Ballot Measure 37 passed by the margin which it did. Instead, what you have to do is you have to look at what happened since the passage of Ballot Measure 7 in 2000 to understand why Ballot Measure 37 passed. I ask you, how did the governor and the opponents of Ballot Measure 7 5 years ago react to the passage? Well, we all know they went to court, but they did nothing, absolutely nothing, It was the second time that this measure was passed, first in 1995 by the legislature, then in 2000 by the voters. And yet the governor, who promised to modernize our land use system and take a good hard look at it, said no. He did absolutely nothing. And how did local governments respond to the passage of Measure 7? Many local governments thought they were being clever by adopting unbelievably high transaction fees and unbelievably cumbersome processes in an attempt to dismantle the protections of Ballot Measure 7. In other words, the government was telling Oregonians, we know what you said, but we don't care. The message the government sent to Oregonians was that they were intent on protecting a system that benefits the few at the expense of the many. And the last straw was the 2003 legislative session. Oregonians in Action told legislators, we said, look, if you pass a comprehensive lot of record bill and a measure that would help out 92-year-old widow Dorothy English, you wouldn't see Ballot Measure 37 on the ballot. And what happened? At the urging of Diane Lynn, Thousand Friends of Oregon, the Oregonians editorial page, Governor Kulongoski vetoed Dorothy English bill. And the lot of record bill, the opposition of Thousand Friends and the governor of the state, passed the House, but failed to get out of the Senate. And so the message was sent to Oregonians. The only way Oregonians were going to be able to protect their rights and restore some semblance of sense to Oregon's land use system was to do it themselves. That is why Ballot Measure 37 passed. And how did it pass? We were outspent 4-1. Our opponents had hundreds of thousands of dollars from out-of-state interests, those well-known property rights groups like the Sierra Club and Defenders of Wildlife and the League of Conservation Voters. Ballot Measure 37 did not receive one single newspaper endorsement. In fact, during the last 2 weeks of the campaign, we thought the Oregonian had changed their name to the No on 37 brochure. So how was little old Oregonians in Action able to pull off such what many people are calling such an amazing victory? One word: fairness. Despite the overwhelming opposition from urban elitists and the government classes, we knew that the current system is so unfair that there is no possible way for our opponents to explain how the system is fair. Because our opponents were the ones who were primarily responsible for making it that way. We knew they had absolutely no credibility on the issue of fairness. How can anyone possibly justify the way in which Multnomah County has used its land use laws to destroy Dorothy English's retirement? How can anyone explain why it makes sense that the city of Portland fined Rebecca Mateen $15,000 simply for removing blackberry bushes in her backyard? How can anyone possibly explain how it's fair that Barbara and Eugene Preddy have horses that can live on their 20 acres just outside of Sisters, but they can't? Make no mistake, Ballot Measure 37 passed because our system of land restrictions is out of control, controlled by planning zealots, morphed into a system that prohibits snack shacks on golf courses. I'll never forget in 2003, I'm sure Director Shetterly will remember this, we had a bill on the floor that would allow snack shacks on golf courses, sell hot dog, beer, and pop. We needed that bill because the opponents said, well, if you allow this, they're going to put 5-star restaurants at the turn, which is, any of you who golf know how ridiculous that is. And I went up to Director Shetterly when he was still a state representative, and I told him about the bill, and his response was, we have to pass a bill to do that? Yes, we did. All we had to do was remind Oregonians that the opponents of Measure 37 also opposed such controversial measures like the golf course snack shacks, spring water bottling plants, model airplane clubs, maggot farms on farmland, claiming that allowing those uses on farmland would gut Oregon's land use system. Think about it. In Multnomah County today, barns are not permitted uses on farmland. You have to get a conditional use permit to put a barn on farmland. Explain to me how that makes any sense whatsoever. All we had to do was remind Oregonians that in Oregon, a state with the highest unemployment and the slowest economy, restrictions on the use of land in Oregon have as much to do with our dismal economy as anything. And if you don't believe me, just look at the front page of today's Oregonian. They're talking about this Cascade Station and the fact that Oregon's land use laws are deterring IKEA from moving into the area. So on November 2nd, the voters of the state said enough is enough. Make no mistake, that is exactly what they told us. They put an end to years of abuse by the chattering classes and overwhelmingly approved the most protective private property rights legislation in the country. So then what does the passage of Ballot Measure 37 actually mean? Again, anyone who thinks that the voters didn't send a message on November 2nd is living in a dream world. Ballot Measure 37 received more votes than any other initiative measure in the history of the state of Oregon. Ballot Measure 37 passed in 35 of 36 counties, including Multnomah County. It passed in 27 of the 30 state Senate districts. In other words, David beat Goliath, with the role of David being played by the rancher in Eastern Oregon, the husband working swing shift at the plant in Cottage Grove, or the family in Gresham preparing to cut down their trees because they're afraid they're about to be imposed an environmental overlay zone by Metro. Anyone who thinks the voters of the state did not proclaim loudly and clearly that our land use laws need major reforms either cannot or will not admit the obvious. But unfortunately, so far, the governor and many local governments seem to be ignoring the messages sent by the voters. Immediately after the passage of Ballot Measure 37, and I mean at 8 a.m. on November 3rd, lawyers for local governments began posting messages on listservs asking, how do we get around Ballot Measure 37? What's more, many began parsing the measure, looking for ambiguities where none exist. For instance, one red herring about Ballot Measure 37 that has been getting some play is this idea about transferability of waivers. First of all, waivers, that word is not found anywhere in the measure. The governor and many local governments and our opponents are claiming that waivers aren't transferable. How in the world can anybody honestly say that the voters of this state approved the measure restoring rights but didn't intend for people to be able to exercise those rights? That suggestion, I think, is insulting to the voters. And it's that kind of logic, and I use that term loosely, that led to the passage of Ballot Measure 37. If the governor and the local governments in this state continue on this path, I can guarantee you they'll be staring down the barrel of yet another ballot measure to help them understand what the voters really meant. But the legislators I've talked to from both sides of the proverbial aisle have told me the same thing. Ross, we should have listened to Oregonians in Action. Given that over the last 6 years, Oregonians in Action has passed 3 major ballot measures addressing Oregon's land use system, I think they finally got the message. The good news from our perspective is that they have received the message. The chairman of both the Senate and House Land Use Committees, one from Raleigh Hills, one from Klamath Falls, have both promised to take measures to make the system more fair and allow rural Oregon especially to begin the process of economic recovery where they need it the most. The answer to the question, what next, depends on how the governor and local governments and the legislature, and the opponents of Measure 37, react to its passage. Many local governments, fortunately, east of the Cascades and south of the Valley, are doing a very good job. We're very happy with what they're doing, and they're honoring the will of the voters. But if the governments here and the urban elitists here in the Valley continue, as they have since November 2nd, to make it next to impossible for property owners to exercise and enjoy their rights, we will likely be here again discussing yet another ballot measure passed by the voters, in which the voters told the government they want their rights back. During the last gubernatorial election, we heard a lot about the 2 Oregons. The result of Measure 37 suggests, at least, that divide between the 2 Oregonians, between the 2 Oregons, is actually beginning to narrow. The 39% who did not support Measure 37 are quickly marginalizing themselves into obscurity. Every time they try to tell the public with a straight face that mixed-use development is popular, or allowing one dwelling on a 20-acre parcel of sagebrush in eastern Oregon will destroy agriculture in Oregon, their credibility and influence with the public wanes. Ladies and gentlemen, make no mistake, the passage of Ballot Measure 37 happened for a reason. The uncompromising style of the past by special interests, government bureaucracies, and the enlightened elite who insist on making the rest of Oregon their personal playground led to the revolution. Now, I'd like to end with a statement that former State Senator Hector McPherson gave to the Joint Land Use Committees on Monday. He said, "I think we have to do something regardless of what happens to Measure 37. The people, 61%, said we have to do something serious about land use planning. And what I found when I was out on the campaign trail was that the people said we haven't gotten any satisfaction, any loosening up. We need to look at those kinds of things, and we can make it a whole lot fairer to everybody if we went in that direction." It sounds to me like Senator McPherson got the message. I hope everyone else does too. Thank you.
Thank you very much. It's a pleasure to be invited here today to bring to you something of a report on the status of what the state is doing in response to Measure 37. And Ross, Bob, appreciate the opportunity to follow both of you, and I'll put the state perspective on this as best I can in the few moments that I have. And Ross, I want you to know I don't take any of that personally. Ballot Measure 37 is the law, and I can assure you that whereas the governor would not have advocated and did not advocate for the measure, the governor recognizes his constitutional obligation to recognize the effect of the measure, and following the election, we at the state undertook an effort immediately to develop a response to the measure to implement it. We recognize that 30 days from the date of the election, that being December 2nd, would be the effective date of the measure, and there was a lot of work to be done in the short term to begin to build a process for receiving claims. As you know, under the measure, the process begins with what in the measure is referred to as a demand for compensation. Then that demand for compensation is vetted against the criteria in the measure to establish a basis for a claim for compensation. Once that has been established, the government responsible for the claim or for the regulation then has the option either to pay compensation or in lieu of compensation to remove, modify, or not apply the particular regulation. Ross is correct. Waive or waiver is not in the measure, but is usually used as shorthand for remove, modify, or not apply a regulation. This is new. There was no vehicle in place under law by which to receive these demands for compensation or to process them. And so the first order of the day following the election at the state was to develop a state claims process. That in itself presented some very interesting challenges. Under the terms of the measure, it applies to land use regulations, but that phrase, land use regulations, is defined broadly enough that it encompasses far more than what you might typically consider to be the statutes, rules, and regulations under the Department of Land Conservation and Development. It specifically calls out the Oregon Forest Practices Act, which falls under the Department of Forestry. It also specifically calls out regulations affecting agriculture, which calls out the Department of Agriculture, but in its scope extends to potentially many more state agencies having some regulatory authority. As such, the process at the state had to be created so that it was going to be uniform across all state agencies, so that we didn't have situations where citizens may have different experience, different process in filing a claim in the Department of Forestry from what they might find at the Department of Land Conservation and Development, Department of Transportation, Agriculture, or any other agency, board, or commission. So that meant bringing together all of the disparate agencies that are potentially affected by the measure and creating a single uniform claims process that is centralized in the Department of Administrative Services. Under the state program, a claim is received by the Department of Administrative Services. It evaluates the claim to make an initial determination whether there is enough information on which to evaluate the claim in substance. Assuming then that there is information, that claim is referred by the Department of Administrative Services to the appropriate regulating agency that then makes the substantive review and the determination to pay or to compensate. I didn't mean to suggest pay as an option particularly. There is no general fund identified from which to pay compensation in this budget. So clearly for the time being, a decision to remove, modify, or not apply is going to be the most likely decision made with regard to validated claims under the measure. I don't think there's any secret about that. There is a possibility, and in fact a probability, that most claims filed under the measure will have both a state and a local impact. That is because most claims that will come into the measure, under the measure, probably will be through our land use ordinances and statutes, regulations under the Department of Land Conservation and Development. And many of our state statutes and department rules and statewide goals require the adoption of local ordinances, particularly relating to farm and forest lands in the counties. So you'll have claims come in seeking relief from a county ordinance that in fact may have a state overlay as well. And so we have been working as well not only to coordinate the state claims process, but also communicating on a regular basis with cities and counties while this measure is implementing to make sure that we are as coordinated as we can be in our claims process. Again, recognizing that many claims may have both a state and a local component. I will tell you that is one of the things in the measure that is not clear, and that is the question of who has authority to remove, modify, or not apply a particular regulation. It says it twice in the measure, but it says it in different ways, creating a suggestion that in one case only the regulating, the government entity that enacted the regulation has the authority to remove, modify, or not apply, and in another case suggesting that that authority may be broader. Given the fact that there is uncertainty on the point whether a state statute or rule may be modified or moved or not applied by a local government, and the practical implication of that down the road, the best practices from attorneys who are advising clients these days is to file claims in both the state and at local government wherever there is this possible overlay. So we are working to coordinate not only across state agencies but also vertically with local governments as well. As Ross said, local governments have taken different tacks in how their claims processes work. Some require filing fees, some do not. The state does not. Some require the filing of appraisals with the claims. Some do not. The state does not. Some local ordinances create or purport to create a private right of action in favor of neighboring property owners whose property may be devalued by a decision by the government to waive, modify, or not apply a land use regulation. The state does not expressly create that private right of action. So there is a lack of uniformity in this claims process that reflects local political and policy determinations across the spectrum of cities and counties statewide. One of the efforts in the legislature this session will be to look at how better to unify that claims process. Last Monday, the House and Senate land use committees held a hearing to get an overview on the measure and some of the issues, and Ross's enthusiasm for the measure aside, heard a steady litany of concerns expressed not just from the chattering classes or from the urban elitists or the government class, but from bankers, realtors, developers, representatives of the agriculture and timber industry, concerned about several uncertainties in the measure that may, in fact, make the measure difficult to achieve its intended purpose. without one of two things: either legislative clarification, if that can be accomplished in this session on issues such as the question whether a waiver is transferable to a succeeding property owner or not, the decision on who has authority to waive a land use regulation. Those questions can be clarified by the legislature. If they are not clarified by the legislature, more than likely what you would see would be a series of lawsuits across the state as these issues arise organically from the filing, processing, and action upon claims. And that process, of course, would originate in our trial courts in the various circuits across the state and may take a period of years before all of the sideboards could finally be determined on the measure through the process of appeal to the Court of Appeals and ultimately the Supreme Court. The department is committed, as is the governor, to implementing the measure. Those of you who have dealt with statutory interpretation know that the Supreme Court has directed the approach that laws, this is both legislatively enacted as well as initiatives, are to be interpreted first based on their text and the context in which that text appears, that is the context of the other statutes with which the measure or the law interacts. That is the basis on which the state is addressing the interpretation of the measure, asking the question in each case, if this question is litigated, on what side will a court most likely land in making a determination so as to limit our exposure to incorrect interpretation of the measure. So we intend to be as accurate as we can be within the construct of statutory interpretation that applies to the measure as well. To the extent that the legislature goes forward in this session with any clarifying legislation, we intend to be at the table playing a productive role. We understand that the policy of the measure represents a significant shift in historical policy and does represent certainly a statement from the voters that cannot be ignored, but also needs to be made so that it can be accommodated and done in such a way as to avoid the risk of litigation, unintended consequences, and a host of other results that may not have been foreseen. We will work with the legislature, we will work with the proponents and all other interested parties from local governments as well as into the private sector to try to make this work if the legislature is going down that road. Failing that, we will do our best to implement it as written and then address the issues that arise in the course of litigation. It's going to be an uncertain time ahead. The time of that uncertainty may be short if the legislature acts. It may be much longer than that if the legislature fails to act. But I do want to assure those of you here today, as well as at the head table, we intend to move forward in good faith and doing the best that we can in implementing this measure according to the text, according to how it was written, and in that way honor the will of the voters. Thank you very much.
Thank you for that possible clarification. We now come to the question and answer period, and I would like to point out that questions may be asked only by City Club members. I would also like to add that I see a lot of people in the room who are not members, and I would invite you to raise your hand, and one of the staff will come and immediately make you a member. I would say as well that you've heard me mention many of the benefits that City Club members have, so it wouldn't be just the opportunity to vote today. I would also like to tell those who are lining up to ask questions and who may consider asking questions that please do limit your question to 30 seconds, and we have a lot of people who will want to ask them, and please make sure that they are respectful. I will now introduce our board host who has the opportunity to ask the first question, and he is Marcus Samantel, who is a retired farmer and has an extensive history of community involvement, including the Washington County Planning Commission. He's currently shares oversight of the Issues Committee for City Club.
Thank you, Carlene. Well, I wish I had 15 or 20 minutes to respond to what I just heard and to ask questions of my own. Before I ask my question, a couple of things. If you're not acquainted with City Club's Measure 7 report that was put out in 2001, it has so much valuable information on this topic, and I urge you to get a hold of that if you have not looked at it in a while. I also have a copy of Senate Bill 308, which Senator Kurt Schrader is putting forth to the legislature, which is an effort to take Measure 37 and make it more workable. It includes some very interesting aspects, including compensation and a special tax to fund that compensation. Then I have a record of the claims. I think this is up through January 17, and it's very interesting. I think there are 70 claims put in so far in Measure 37, and almost all of them are requesting a waiver rather than dollars and cents, and probably that is what will happen. I'm a great believer in Senate Bill 100, and we hear so often that Senate Bill 100 and our land use program here in Oregon is there to preserve farmland. Being a retired farmer, I certainly believe in that. But I believe that we have ignored over the years what Senate Bill 100 did for cities and urban areas. I don't think Portland would have the Pearl District. I don't think they would have Northwest District the way it is with its density and its vibrancy. I don't think it would have South Waterfront coming on the way it is without Senate Bill 100. It has not only done great things for land use out in the rural areas, it has forced cities to do a better job of using their lands. My question is, I'd like all three speakers to look down the road 10 years from now and tell us what you speculate the urban landscape will be like, or how it will be different as a result of Measure 37. Starting with Ross, because you're all going to just sit there, right?
Well, boy, I don't know that I'm able to predict that. I mean, I really don't know. I mean, it could look the same as it does today. It could look different. I've just got no idea. I agree. Yeah, exactly. Go ahead.
We'll go down the table, Bob, Stacey. In the next 10 years, the North Willamette Valley will see 450,000 more residents, matching its performance in the preceding decade. 450,000 additional Oregonians. They will locate where market and planning forces allow development. The adoption of Measure 37, the granting of large-scale waivers, provides additional areas for that development, which will compete with the carefully laid plans of the Portland metro area, Salem, Woodburn, the other cities of the North Valley. One example, directly outside our urban growth boundary to the west, in the triangle between the Sunset Highway and the cities of Cornelius and Forest Grove, west of Hillsborough, that exclusive farm use zoned land, roughly a third of it is in the same ownership as it was in 1972 when Washington County first adopted farm zoning. If a significant fraction of those property owners feel compelled by their neighbors' decisions to seek waivers of their own and develop 2-acre subdivisions or other development that precedes the previous zoning, that will have a significant effect on development on the other side of the urban growth boundary. In other words, we will have a much more sprawling land use pattern than what we thought we would accomplish with our land use plans.
Yeah, it's really hard to tell. I think the question requires several assumptions. One is that the measure implements according to which vision. If you assume Ross's where waiver rights are transferable, and so you have this effect that encourages that kind of development, particularly on rural lands. I think cities are concerned about the prospect of small acre development on the fringe of their urban growth boundaries, the difficulty that entails in incorporating that kind of development into an urban services design. And then the question, does that require, on the one hand, will that make cities focus even more on infill because of the difficulty in going leapfrogging over that larger scale development on the fringe of the urban growth boundary, or will you in fact see that leapfrogging so that you'll have various types of urban development extending out from the fringes? Very difficult to know. But I think those are all at least concerns I know that local governments have as to the impact of the measure on urban growth boundaries and what that means in terms of what happens inside.
Hi, Jane C., City Club member, urban elitist, and farmer's daughter. I want to ask specifically Mr. Day and Mr. Stacey, do you remember after Measure 5 passed in 1990, how long and hard, despite the fact that the proponents said it was nirvana and the opponents said the sky was falling, which is what I think I heard today, do you remember that we had to work long and hard on making that work? And I want to know if both of you, I already heard Mr. Shetterly say he was going to work on making it work. Are both of you willing to work really long and hard to make this work so that it's fair for everybody?
Of course, Jane, 1,000 Friends of Oregon is committed to doing our best to make our land use laws work as well as possible. I tried to outline the changes I think we need to make. We need to eliminate waivers. We need to find a compensation system that doesn't depend on general tax revenue or new taxes. We need to, if we're going to have a system in which these kinds of claims can be made, we need to provide notice to affected property owners next door, which Measure 37 exempts these waiver decisions from our existing land use laws. We need to provide mechanisms that ensure that the public knows what's happening. But fundamentally, we should be changing Measure 37 to take the waiver out.
Yes. Yes. Hello? I said yes.
Hi. Jim Labby, a City Club member, and I should also say I work for the Audubon Society of Portland. Measure 37 did not explicitly mention environmental protections for water quality, fish and wildlife, and healthy watersheds, which are the public's property that the public owns a vital interest in. And certainly over the last 30 years, citizens of the state have exercised their democratic rights in spite of and sometimes because of our land use planning system to protect those public values. I'm wondering, in looking at review of and reforming Measure 37, or looking at 30-year relook at the planning system, how can we address protecting the public's ownership in fish and wildlife and water quality?
I have no idea how you do that, because it's not an area of law that I practice. I don't know the answer to that's something I think you need to ask a biologist.
Well, I think the question, as I understood, relates to the measure and how there are exemptions in the measure, for instance, for public health and safety, regulations that are required for public health and safety. There's an exemption for regulations that are required to comply with federal law. I think the question is where the exemptions do not extend to regulations that protect wildlife habitat, for instance, where do they fall in the spectrum, and how is the state or how are local governments going to protect those? I think the answer, probably from the proponent's perspective under the measure, is that if you want to protect wildlife habitat, you will pay for it. You will compensate owners whose property is affected by regulations that are intended to protect wildlife habitat. I think under the measure, that's where you go. And it's going to take a change in direction from the language of the measure to effect a different outcome, but I think that's it. Since regulations that affect wildlife habitat may very well fall within the definition of land use regulation in the measure. They are not specifically exempted from the measure. They fall within that broad category of land use regulations that may very well require compensation in order to implement.
I agree with Lane, but I'd be slightly more optimistic, Jim. First, there's nothing wrong with continuing to seek public support for acquisition of important resource lands to protect habitat. That is a tool in the community's toolkit. Oregonians, particularly Oregonians in this metropolitan area, have supported acquisition of lands to protect habitat and other natural resources. We should never forget that tool. Regulation under Measure 37 in the future is going to be extraordinarily difficult, essentially requiring a demonstration that no adverse impact on anybody's property value is resulting from this regulation, or else raising the money in advance to pay people for the right to change their zoning. But I would not rule out the prospect that carefully crafted, consensus-based regulation can be designed, as has been done in this metro area with respect to green spaces and habitat already, to ensure that the same amount of development density is retained by a property owner while requiring setbacks, design modifications, and the like that don't adversely affect property value but pay real dividends in terms of unbroken habitat area on property. That's one technique that we can continue to use.
Bill Michtam, based on the speech you gave today, Mr. Day, it seems to me that rather than bringing Oregonians together, you played on the divide between, as you put them, rural Oregonians on one side and urban elitists and government bureaucrats on the other, as well as by using heart-tugging stories such as 92-year-old widows and families that had to sleep out under the stars with their horses. At no point in your presentation did you talk about 850 house developments or other sweeping environmental effects that something like that could have. In the campaign, do you have examples that you used before the vote that were like the 850 house development, or were they all the heart-tuggers?
Our opponents did an excellent job of getting that scare tactic out into the public. Let me tell you what we're advising folks. Because of the nature of government in this state, particularly in the metro area, I used the example earlier about the gentleman who cut down all his trees because he was afraid Metro was going to put an environmental overlay on his property. What we tell folks is you need to protect yourself because God knows what's going to happen somewhere down the road. So we tell people, apply, shoot for the moon, even if you're just putting one home on there. Do I think an 850 housing development is really going to happen? I don't think so.
But you didn't use that example in your
my
campaign,
instincts tell
true?
me that it's probably not. But the issue was an issue of fairness, and if that person had the right when they acquired the property to put 850 units on their land, that's no different than restoring Dorothy English's rights or Ruth Pruitt's rights or anyone else's rights.
Thank you.
Kathleen Warman, City Club member of Oregonians in Action, and one of those people who's been treated grossly unfairly by Multnomah County Planning. I own 22 acres, and I applied for an interpretation of their template test. I asked whether or not they would count a dwelling on the template boundary in the count. They said no. We used Black's Law Dictionary to describe the word within. They used Random House Dictionary. Meanwhile, my question is, given that Tannisbourne Mall, the high-tech industry, and all the residential area built in Washington County on topsoil that's 20 feet deep, are our land use laws designed to protect farmland and forest land, or is it merely to provide green space on the backs of private property owners?
May I? It's a very good question to ask what guides our planning decisions when resource lands as valuable as the Tualatin Valley are at stake. And Marcus's Washington County agricultural colleagues have been very concerned about just the trend that you've identified. I'm pleased that in 2002, Metro took about 700 acres of farmland on the west side and 13,000 acres of land that was already partially developed with rural home sites and the town of Damascus into the boundary on the east side in a concerted and focused effort to try to encourage development away from the prime agricultural lands of Washington County.
Chris Smith, City Club member. City Club has historically had some pretty stringent policies about what's appropriate for use of the initiative system, and I won't talk about how City Club came down on this measure for fear of marginalizing the club. But I think it's fair to say that the club would not find that the ping-pong match of initiative, lawsuit that we're in is the right way to make policy on this issue. So my question is, why did the intensive effort in the 2001 legislature to come up with a legislative fix to this issue fail, and why will it, whatever happened then, not happen again in the 2005 legislature?
Well, I think Bob and I are going to point fingers at each other. We're going to say that Thousand Friends blew it up, and they're going to say that Oregonians in Action blew it up. So I don't know that you're going to get believe who you want. With regard to the Portland City Club, we actually used your Measure 7, your objections to Measure 7, as one of the templates for the measure. And I thought it was particularly curious that they came out against the measure. And I spent time with your committee explaining to you exactly why the measure addressed everything that you talked about. I couldn't agree with you more that going back and forth is really unproductive. But I don't know how many times the voters have to speak before the legislature and the governor get the message, and they'll keep doing it. And they need to wake up and smell the coffee, understand that this just isn't going to fly anymore.
I was out of state during the 2001 session, Chris, but I will concede, I will agree that it's tragic that the work that Kurt Schrader and Max Williams attempted to do to bring parties together and come up with a legislative replacement for Measure 7 was unsuccessful. And because I wasn't there and wasn't firsthand, I won't comment on whose fault it was. I know that Oregonians in Action was permitted to engage in those negotiations for most of the session. 1,000 Friends was not permitted to until very late. I take personal responsibility for not urging the 2003 legislature to take that up and instead passively allowing the legislature to move on to other subjects without trying to come up with a compensation strategy in 2003. That was a mistake.
We are out of time, but did you want to take this one last question? Okay.
I'm going to ask you gentlemen, Guinevere Milius, City Club member. I'm going to ask you gentlemen to step outside the usual discussions of land use you have and talk a little bit about investment. It seems to me that through Measure 37, we've created a special class in real estate investors by protecting them from government regulation, where other investors, say if you bought stock in a company that fell under government regulation and then your stock lost value, these people aren't protected. Do you think this is a trend nationally in legislation where if you put money into something and a government regulation comes along and affects its value that you have a right to sue, or is this something that we're going to keep to real estate?